Yes, sir. Sure. Sorry for the delay. Good evening, everybody. Good evening again. Is it exciting? Well, I'm excited that this day is happening, and I'm welcoming all of you today. Thank you so much for coming. Sorry for the late start. I wanted to make sure that those online are able to connect. So my name is Attorney Jumoke Oladapo, and you're welcome to the Wills Trust and Appetizer seminar. It's about estate and legacy planning, how to avoid the three biggest mistakes in estate planning. This is put together by our office, IB Law Office. I'm super excited to have you spending some time with us today, and I hope that it's going to be a time worthwhile spent for you and something that you will appreciate not only for you but also for your family. Um, so that's a little about me. I'm the managing attorney at Ivy Law Office. Our office is opposite this building at 6301 Ivy 6305 Ivy Lane Suite 605. And this evening, as we're about to start, I want to tell you that the best way to make the best use of our time together is for you to please turn off your phones. You deserve this time for yourself and for your loved ones. If you can turn it off, please turn it off. You can put it on silent. Please turn it down and put it on silent. And just please be all present with us. This meeting is going to be for about 2 hours. We want to make it just about that sharp. It's going to have some questions and answers built in that 2 hours. So we'll make the best use of it together. I'm going to go to some housekeeping. First of all, this is an educative session. Please do not give too much personal information when you're discussing or when you're asking questions because people are online. It's going to go on YouTube Live. It's going to go on Facebook Live. So ask your questions, but don't give out too much personal information. Also, this forum does not create an attorney-client relationship. You become a client when you sign the dotted line called engagement letter, and but you can ask your questions, and also we'll give you an opportunity to probably have further interactions with our office after this meeting. Questions will be answered at the end of the session, at the end of the seminar. So please, you have a notes pad in your blue folder, and make use of that to jot down your questions. And at the end of the meeting, we will be answering all questions. Also, we have a green worksheet. Everybody got one in your folder. We're going to be making use of this as we go on. I want you to please, at first, fill in your information, your contact information. All the things you put on the sheet will be treated as confidential. So we're just going to be for our office use. We're not going to be sharing it with outsiders. And we'll be making use of this in form of an interaction. You'll be answering some questions as we go along. Please bring it out and use it effectively. At the end of the meeting, you're going to be giving this back to us, and we're going to be giving some gifts. And the gift we're going to be giving is called the golden ticket. So at the end of today's session, if you submit your orange worksheet, you're going to be getting what I call a golden ticket. It's a complimentary one-to-one meeting with me or with an attorney in our office. And it's just going to be focused on you, your family, your loved ones, your assets, and how to protect them. Also, when you submit the green worksheet, you'll be given an opportunity to get what we have here called a gift certificate. at the end of the meeting. The gift certificate is going to give you something nice that I'll share with you later. It's a $750 credit towards a planning session. You're going to learn more about it. You'll also have another gift certificate when you schedule for a planning session. And also, we're going to give you what we call a digital asset spreadsheet checklist. The digital assets checklist. How many of us have digital assets? Emails, passwords, usernames. Do we have a lot? I know I have not less than 100 of those, but they are part of our plans. They are part of the things we need to keep. Uh, uh, so we'll give this out to us when we schedule a session today. So please stay here till the end to be able to get these gifts that we would like to give to you, and also for us to be able to answer your questions. Thank you so much. And moving on, I want to find out how you found out about us. How did you find out about us today? Did any one of us hear about us on Facebook? Thank you. Google? Thank you. Did anybody get this in the mail? No. Anyone personally invited? Thank you. Thank you so much for coming. How did you find out about us, sir and ma?
I was just looking for things.
Eventbrite or just online?
Online.
Just online. Okay. We appreciate all of you. It's a pleasure. It's to have you here with us. Thank you so much. We don't take it for granted. We don't take it lightly. You could have been somewhere else this evening, but you chose to be here. So thank you. All righty. So moving ahead, we just want you to be here, be present, participate. Okay. When I ask question, please answer. Don't let it be a boring session. Okay. So I've spoken about the golden ticket, and now we're moving on. So just a little about our office and our process. So this session is put together by Ivy Law Office. As I said earlier on, we're in Greenbelt, opposite 6305 Ivy Lane. I'm the managing attorney at Ivy Law Office. My name is Attorney Jumoke Oladapo. Just call me whichever one you remember. it's not the easiest of names to know. But anyway, Jumoke. All right, say Jumoke. Jumoke. Okay. So over the years, we've been in practice for about 13 years as an attorney and as a law office, and we've been privileged to serve thousands of individuals and families and businesses. Our focus in our office is there are two practice areas: immigration law and estate planning. So, as an immigration attorney, we can serve all over the nation, but as an estate planning attorney, we're licensed only to serve in Maryland. Okay, so if you live in Maryland, you have assets in Maryland, then you're at the right place, and we can serve your needs. We've been given quite a number of awards over the years, and one of it is the Lawyers of Distinction. We've been named the 10 best attorneys in Maryland for immigration law. We've also been named one of the 10 best law firms. We have a lot of Google reviews that are 5 stars, and anyone that knows about that knows that it's not cheap to get one. That means you have to really earn, what you have there. And we have probably 80 or more live reviews on Google. And thankfully, they are from clients that had great satisfaction with what we did for them. Also named a top attorney on Avo, and also specifically for estate planning, we're licensed to be a personal family lawyer. but for estate plans. And this is a special designation to be able to not just be a traditional lawyer for estate planning, but to have a model that will serve our clients best. So in our office, um, we serve in such a way that we want your plans to work for you when needed. So it's not just that you will say, "Oh, I need a will," and we'll send something to your email and you won't make any use of it. At the end of the day, some people are so overwhelmed by the volume of pages of legal documents that they don't even execute it and refine. And a lot of people have come to me that way, and I'm like, "We'll prepare it for you." Lawyer X, but lawyer X probably had 10 areas of law that he's working on and he's not an expert in anything. It's good to use experts in different areas of law when you're working with an attorney. So we are experts in both immigration law and estate planning. So when it comes to estate planning, it's not necessarily about you, it's for your loved ones. Okay. And for me, these are my loved ones. This is my family. These are my wives. I don't want to work hard and at the end of the day leave a mess for my family. In that you have a whole lot of things and your family don't know how to find them or where to find them, and you get a lot of things lost to the government. So I decided to put my plans together to make it easy for my loved ones when it comes to planning after I'm gone and also in the event of incapacity. So I have three lovely daughters and my husband, and one of them is a minor. When it comes to estate planning, minors are special. So you have to, if you have minor children, you really need to know what you're doing so that you're planning right. Okay. So, how many of you have children under 18? Anyone with children under 18? Okay, nobody. So, I have like one or two things to skip when we're talking about children. Do you have grandchildren, or do you have grandchildren? Okay, so maybe I'll talk about it for the benefit of your children's children. Okay, this is our team. We have an associate attorney, Attorney Well, and we have a staff. Miss Moji, Miss Princess, Miss Taya. Miss Moji and Miss Princess are here with us today. And we all work together as a team to serve our clients with excellence. So, moving on, do you currently have a plan in place? Do you currently have an estate plan in place? Anyone who's done anything related to planning? Maybe you've prepared a will before, or a trust, or a power of attorney, or healthcare directive. Anyone? No. Okay. But you've heard about it before, some of it. Am I right? Have you?
Sure.
Okay. So if you've not done a plan before, if not, why not? Can you tell me, shout out why not? One or two of you, please.
Wasn't sure what to do. Procrastination.
Procrastination, not sure what to do. Thank you, any other person. Here's some reasons, okay? Some people say, I'm too busy. Well, and I think that falls into procrastination, We just keep moving it to another day because a lot of people live busy lives, actually, but if you don't take care of the things that matter, then sorry, some days it may be too late. Some people say I'm too young. How old is young, and how old is the right age to have an estate plan in place? Does anybody fall into the category of I'm too young? Does anybody fall into the category of I'm too busy? No? It's too expensive. Do you have any idea of how much it costs? So does this resonate with anyone? Maybe I need to have more reasons on my issues. Does any of these resonate with anyone? No. So tell me your own reason so that I'm relating to people that are here. Tell me, sir, what's your own reason?
Um, I just not too long ago figured out, I guess, learning about kind of trust and that kind of thing. So I've been inquiring about it more. So that's why I'm here to kind of learn about.
Okay.
It's not known for everybody.
It's you just knew about it
Yeah.
not too long ago. Any other person?
Like I said, I've known about it, but just don't know where to start, what to do.
Okay.
So confused.
All right.
I want to learn about revocable will and trust.
Okay. All right. So basically, a lot of us are present to be able to learn more. Am I right? Okay. So maybe we've not had about the concept in a long time and we want to know more about it. So we're going to learn enough for today. I'm not going to overwhelm you, but we'll learn enough for today and show you how to move forward in the practical way. So this does not really apply to us because none of us have had a plan in place before, but these are some of the reasons. Maybe better understanding can fall in place in this.
Okay, you just look at it when you say updated, because if you have written a will, how often do you need to update your will?
You'll find out. So let me say. So if you're here and you've already found you already have a plan in place. You may be here because your will or your trust is outdated. And what does that mean? The law can change. Am I right? When will or trust or power of attorney is drafted according to old law and there's a change in law, then you need to update your plan so that it works and is aligned to the current law. Okay, that's number one. Number two, your assets may have changed. So let's say, for example, you had one home before that you said I gave my house to X. Now you have three homes. Am I right? And you're supposed to account for the other two. Am I right? Or maybe the beneficiaries or the people that you wrote as agents may have changed. So, for example, let's say you list A, B, C as your agents or personal representatives on your legal document, and B has passed away or A has passed away. You need to make a change. Am I right? Or maybe you had some beneficiaries before, and one of them is no more. They specifically named, and one of them is no more. You need to have a change. So life can change, assets can change, the law can change. That's why you need to update from time to time or review your estate plan from time to time so that it doesn't go outdated. I'm going to share a story later on. So, why are you here today? I know you've told me why you're here today, but these are some reasons that I want to share with you. If you're here to make sure that your family knows what to do after you're gone, okay? And to have your family protected in such a way that your assets are not going to be lost, and to know what to do and how to take care of everything that concerns you, you're here for the right reasons. If you want to have the peace of mind of knowing what happens to your assets after you're gone, or in the case of incapacity, you're here for the right reasons. We all work hard, am I right? And if we don't plan well, the state will have a plan for us. So we need to know how to plan so that the state will not take that which belongs to us rightfully, unnecessarily. So we get taxed. Am I right? Who pays income tax? If you're an employer, maybe you have employees and you pay some payroll taxes. Am I right? And do you pay, if you have a home, do you pay real property taxes? You, so if people die, they pay taxes as well. Okay, and there are different types of taxes. There is estate taxes. There is inheritance tax, probate costs, probate fees, a whole lot. I just call some things probate tax. Okay, when you die, tax. So if you want to know how to save on some taxes and you don't want to be paying unnecessary taxes, you're here for the right reasons. Okay? Also, when it comes to self care, if you want to know, if you want to make sure that you yourself, not just your assets, you are taking care of the way you really want to be taken care of, and you want to name people who will take care of you in the event of incapacity, that's part of estate planning, and you're here for the right reasons. Do we see that it's like broad? Yourself, your assets, your taxes, and a whole lot more. Your children, a whole lot more. Okay? Also, we'll be touching about the Department of Unclaimed Properties. And going straight into that, do you know that a lot of assets get lost because your family and loved ones don't really know everything you have or how to access them? Do you agree with me? Yeah. So let's say, for example, you have 5 bank accounts and your children only know about 2. When you pass away, they're only going to look for those 2 they know about, correct? There are a lot of bank accounts. There are a lot of investments, CDs, stocks, bonds that gets lost to the government, even homes. You know, that is lost because the loved ones don't know their parents have such properties. And in Maryland, we have over $700 million worth of unclaimed assets in the Department of Unclaimed Properties. It's like 1.9 billion, since they've been doing it probably for a few years. Yours may even be there while you're alive, you don't know. Do you know what? I found my name um, among this record a few years back, and I was like, well, I'm not dead. you know, what's my name, or what is it that I have in the Department of Unclaimed Properties? Do you understand? So I made some search, and when I got there, I found out that they said, oh, you have like $500. Um, a check was sent to your house some time ago, and the check returned, and after 3 years, nobody claimed it, and that's how it got there. So I was like, 3 years. I made the calculation and found out that I had to move about that time. The check came and the check left. And I was $500 richer, But do you know how many bank accounts would have been lost? Do you understand? For some of us that, we're very financial savvy. For example, when I looked at how many bank accounts I had, on my profile, it was probably about 10. How many of them do my family know about? Probably 2. Do you understand? Because I am the one that has access to that to that account. And if I don't share that information properly, and if I don't document what I have, it's going to be lost. Do you understand?
Is there POD form enough to collect the funds?
POD.
Yes, pay your debt.
Mm-hmm.
Is it enough to collect the funds?
Okay. We're going to answer all questions at the end of the session. But yes, POD can transfer transfer the funds to the
Without
beneficiary.
limit, the amount?
I don't know about whether there's a limit or not. I don't think there's a limit either. Okay. But yeah, there are various ways of planning, and that's probably one. But we'll tell you more about it and the side effects. Okay. Remind me again. So, if you want to be able to make choices on how you'll be taken care of, if you want to have a total assurance that your family will be well taken care of after you're gone and who you want gets what you want to give them, if you want to have the peace of mind of knowing that your asset goes to the person you want and not the government, and the comfort of knowing that you've done the right things for your loved ones, that they'll thank you for it, you're here for the right reasons. Okay? Please, again, I want to remind us to start using our worksheet, the green worksheet. The first session, please put your name. For those who came later, I said earlier on that please, everything we write here is going to be confidential. Fill out your information in the first session. The second session, I'm going to be asking questions as we go on. So if something relates to you, for example, I may ask, if you want to keep your family out of court, please check the box. Please check it. If you need a living trust or you want to review an existing trust, please check the box. Please check it. That's what we're going to use this for. And there are other things. The third section is what services are we going to be able to render to you? What next steps do you want to take? How else can we serve you? And also comments about this workshop. So make use of this, and at the end of the day, please submit it to our staff to get a gift certificate. So we'll start using the worksheet now. What is estate planning? One of the things that I heard from you is that you want to learn more about what this is all about. Am I right? So, this is a simple definition of estate planning. It's planning in advance and naming who you want to receive the things you own after you die. Planning in advance. Am I right? It's a good way to start an estate plan. That's a simple way, but estate plan is so much more. We've spoken about some things earlier on. But it's planning in advance, naming who you want to receive the things you own after you're gone. It also encompasses things like incapacity, planning for incapacity, planning for children. Okay? So, when you hear the word estate, what do you think of? You want to say something?
Can you say it again?
When you hear the word estate, what comes to your head?
Home.
Your assets.
Like your assets, like a home, what? Your money, yes. You see, a lot of people, a few people, not a lot of people actually, when they hear, estate planning, they think about real estate like your home. But estate planning is not about real estate, but it relates to how you treat your real estate, okay? So everybody has an estate, no matter how small it is. So these are some things that fall under what an estate is. Basically, your assets, your car. Do you have a car? Does anybody have a car? Yes. Your furniture, Do you have some in your home? Your home? Do you have a home? Yes?
Yes, yes.
Okay. Do you have some life insurance or one life insurance? Yes?
Yes.
Okay. Checking accounts, savings accounts,
Yeah.
investment accounts or investments? Yes?
Yes.
401ks, retirement accounts? Yes? Personal possessions, your jewelry, your artwork, things like that. Anything that when you turn your house upside down, it falls down. Does anybody have like other personal possession or personal properties? Yes. Your clothes. That's part of it. Alrighty. So, do you agree with me that we all have estates?
Yeah.
We all do. We all do. So when people say, "Oh, I don't have anything," which I hear a lot of times, do we really not have anything? No. Am I right? If you count your blessings, you'll know you have some things. You probably have shoes and clothes and maybe a car, maybe not, maybe one account, a home. You have something, okay? So I'm saying this to let us know that everybody got something. It doesn't have to be a lot, okay? And when you have something, you have to make plans for it. So, estate plan, we've spoken about everybody got an estate. So, and we also said that estate planning is planning in advance so that the people, we give what we have to someone after we pass away or in the event of incapacity. So, why do people not plan or fail to plan? One of the biggest fear is that a lot of people wait for so long because they think planning for it means that they'll pass away maybe in the next week. That's the biggest one that I've heard about, you know. But that's not true. It's a myth, it's a fact. Planning will not hasten the occurrence of you passing away. There may be situations where someone made a plan and passed away not too long after that. But those are odds, okay? But planning is like having a life insurance or car insurance, okay? It doesn't hasten the occurrence of death. Just your car insurance. You have a car insurance, am I right? If you have a car, am I right?
Yeah.
You insured your car.
Every year.
Did you insure your life?
Yep.
Yes? No?
Yes.
No. When you insure your car, why not insure your life? Or why not make plans for a whole lot of other things like estate plan? Just make the plan in advance so that you don't, even if you don't need it, you have it. Do you understand? But when you need it, it's there because you've made decisions ahead of time. And all people will have to do is follow the decisions you've made. So these are some other reasons why people don't plan or don't have their estate plans in place. They think it's for old, retired folks, or maybe they still have plenty of time. Not necessarily. If you started building a life, so let's say, for example, you started working and you started having all these things we call estates, or you started having children, then it's the right time to start to put a plan in place. And when is that? Probably in your 30s. Okay? So it's not for old folks, that's what I'm saying. I don't think you have plenty of time because nobody knows the time, when you're no longer going to be alive. Every day we live by the grace of God. So um, nobody's promised eternity right here. So Please, it's not for old folks, and don't wait till you're retired to put a plan in place. I don't have enough. Did I deal with that already? That you got some enough?
Yes.
All right. I'm not. It's for the wealthy. Yeah, that's what other people think, that it's for the wealthy. Have I dealt with that? That it's not necessarily for the wealthy because you got some things. Am I right? Another thing that we hear is a will resolves everything. Who knows about a will? Have you heard about a will before, like last will and testament? Yes?
Yes.
Because that's the most popular estate planning document. So, and that's why you hear, if anybody wants to do anything estate planning, they say, I need a will. Because that's what they know about. And they think a will answers all questions. But this evening, I'm going to let us know that a will can do some things, but there are other instruments, other legal documents that we need. A will does not answer all questions. Okay? And I'm too busy. One question that I want us to ask ourselves this evening is, who needs your protection and what needs your protection? We've spoken about what needs your protection. Am I right? All the things we see, our family, our money, our home, our retirement plan, our life insurance, stock, all those things. Those are things that need our protection. And who needs our protection? Please think for 30 seconds or 1 minute and write it down. Because who needs my protection is maybe different from yours. Can you write down who needs your protection? Write it on your piece of paper. Are we done on that?
Yes.
So, a lot of people, when it comes to planning, they think it's something you do, planning for death. How many of you think, when you have a will, it's about, and all this planning that we do, it's planning for death alone? You know, well, I want us to change our orientation, shift our mindset, that it's not just about planning for death. Yes, it's part of it, but it's not all about it, okay? It's planning for life. While we are alive, what impact can we make in the lives of our children? What can we do for them right now while we're alive that they will thank us for? Okay? So, how do we shift our orientation? First of all, the way we serve our clients makes it, beautiful, I'll say. Because number one, you learn a lot about it. When you come and use the services, it's informative, it's educational. This is a start. You're getting a lot of information today. And in the process of planning, you're going to be making informed and empowered decisions in such a way that it's not an outside third person making decisions for you. You are making decisions for yourself while you're alive. Do you understand? How many of you want strangers to be making decisions for them? Or maybe the decision you can make by yourself, you want your kids to be making such for you. Do you? There's some decisions that we want to make ourselves. Okay? There's some, because if you don't make it ourselves, a judge will end up making a decision for us, or third parties that we don't necessarily want. So we need to plan, we need to put these things in place so that we're making decisions that we want for ourselves, but we're making them in an informed manner, because through the process, we'll be telling you things that will make you understand what you're doing. I'm not just throwing a document in front of you and saying, take, but you're understanding what you're doing and making decisions that way. Also, when you have a plan done, you're going to be saving your family thousands of dollars of your assets. rather than it going to the government. And we're going to touch about that a lot more. I've told you about how some asset gets lost to the government. Am I right? And I've told you a little about estate taxes. Am I right? If you want to save on estate taxes, if you want to preserve your family's wealth, okay, you have to have your plan in place. So let me say, for example, we see a lot of people here that a lot of people in the United States, their children have a better life in some way than they did. Am I right? Because they planned for their children. Some people even left things for their grandchildren and gave them a good start. Am I right? It's because they planned. It's because they had their estate plans in place and they put things in such a way to make life better for their children after them. And when we do this, we are preserving our family's wealth so that our kids can have a better life than we do, or our grandchildren can have a better life than we do. Also, assets will not be lost upon death, and you can protect your family's assets from outsiders. Okay. Um, I think we spoke about that. A lot of assets, when people don't plan, I'll say, for example, let's say, for example, you have a life insurance and you have a child, but you don't want your child, a little child, a minor child, but you don't want your child to probably have direct access to the money, and you put the money in the name of your sister. Do you understand? If you pass away, the money belongs to your sister. But your original intention was for your sister to use the money for your child. Am I right? If the sister is nice, maybe that will happen. Or maybe some of that will go to the child. And if the sister is not kind or nice, sorry for that child. You understand? But people don't plan well and don't think things through. At the end of the day, their monies end up with the people they don't necessarily want. Also, you have a lifetime of real, right legal and financial choices because you have an attorney's office that you can call on to guide you when it comes to your financials, when it comes to your assets, how it's not going to be lost and all that. And also, for me, more importantly, you want to keep your family out of court and out of conflict. Okay. I'm an attorney. How many of us like litigation and courthouse? How many of us do? No. Personally, lawyers make a living that way, but you don't necessarily want to go through litigation. That's why we have corporate law, business law, and the non-adversarial practice of law. Do you understand? So when you have your estate plan in place and you do the right thing, you may be keeping your family from going through the probate court or the mess of the court system. But if you don't do your planning right, you're calling the court or you're inviting the court into your life and into your family. How many of us want that? So plan right if you want to keep your family out of court and out of conflict. But more importantly, when you're planning for life, you are planning so that the legal documents you have in place will work when you need it. A lot of people's plans don't work when they need them. And I gave some reasons. Someone asked me a question, and I said, your life may change, your assets may change, your family may change. Am I right? The law may change. So those are things that affect your plans. And we find that a lot of times people have a will, for example, and when they finish executing the will, they keep it in a safe deposit box or a shelf somewhere, and they leave it for years. Am I right? Until they pass away. And now that one of their children will find that will. I'm using the will because that's the most popular legal document here. And you know what happens? I'll tell a story of what could happen. There is a woman. She was educated enough to have a will in place, and she has a home that she lives in, the primary residence. She had another home, like an investment property, and she had a bank account. Two homes and one bank account. So what happened is that she has three children. So she left one home, primary residence, to one child in the will, the second home to the second child, and the bank account to the third child. The bank account to the third child was assigned to be our personal representative. She lived all these years, probably 15 years later, she passed away. She didn't make a change to her will at any point in time. When she passed away, the personal representative child picked up a will. By 15 years' time, fast forward, there was no more bank account because it's been closed down. One of the homes had been sold. So what was left was the primary residence. So it was out of the three children, only one person could get something. And do you know what? Unfortunately, it's not the person getting the home that was the personal representative. So the person who was the personal representative was not getting anything, so he didn't decide to do his job. So now there was going to be litigation between siblings because one guy was not doing his job as a personal representative to pass title to the one person who was going to get the house, the primary residence. So at the end of the day, was that what the woman wanted? Did she have a will in place? Did the will work for her?
No.
No. So we must, from time to time, review our plans when we have one. In our office, we recommend every 3 years. Or if you, at least, we'll call you or we'll remind you, oh, it's 3 years that you made your plan. Has anything changed? If nothing has changed, fine. We'll call you to come and review. Part of our plan, part of our agreement says we'll give you a free review. And if there's any change to be made, then we'll talk about that. But it's important that your plan works for you when your family needs it. Do we all agree with that? Yes. So I've spoken about when was the last time you reviewed your existing plan, which is not applicable to any of us here. Or if you don't have a plan, then what is the state's plan for you? I said earlier on that if you do nothing, the state has a plan for you. Am I right? If you fail to plan, you plan to fail. Do people say that? Am I right? But if you don't have a plan, the state definitely has a plan for you, and the state's plan for you may not be what you really want. Or do you think the state likes you that much? Do they like us like that?
No.
Miss Uncle Sam? Who is Uncle Sam's friend? Nobody, except when we want to get our tax refund. That's when we're friends. But if you're not getting any tax refunds and we have to pay them, nah. It's not easy. So the state doesn't really have our best interest at heart. So you need to take your life into your hands and do the right thing for yourself and your loved ones. Don't take things for granted. So for those who don't have a plan, they end up in what we call the probate court. For those who don't have a will, there's no way title will pass, okay? If you have a home and the home is in your name and you pass away, people may be living in that house, but the title is going to be in the dead man's name forever if they don't go through the court system called probate without a plan. Do you understand? The bank accounts, if you don't put things in place so that title to the bank account will pass to your children, it's going to go to the government because they can't take the money out except they go through the probate system. But there are better ways of planning, and that's why we're here this evening. Do you understand? We can choose to go through the probate and we can choose not to. But we'll learn a lot about that this evening. So, what's the state's plan for? So, the state's plan, who is interested in knowing what it is? If you don't have a plan, what's the state's plan for you? It's the court process called probate if someone passes away, or the guardianship court if someone is incapacitated. Okay? I'll first go through the guardianship court. So we know that there's some people that they're incapacitated in such a way that they cannot make decisions for themselves. They have to rely on another person to do their daily runs. Am I right? There are people like that. These are things that are unplanned for. People have Alzheimer. People have accidents and get into coma, or they're bedridden in the hospital for a long time. Or maybe they're even at home, but they can't live their daily lives, like going to the bank or calling Medicaid, or going to the court and doing things by themselves. If you don't have the legal document in place, assigning someone to do those things for you, then a loved one will have to go through the through the guardianship court to be nominated a guardian over your person and over your assets. So a judge is going to have to assign someone. And the thing is that because you did not plan, you may be inviting conflict in your family, which is not a plan of what a lot of people want, but because they don't have anything in place, aka called the power of attorney, which is the legal document where you'll use to assign someone, to be your agent. How many of us have heard about power of attorney before? Okay. So while you're alive, in the event of incapacity, you need that document called power of attorney, appointing someone to be your agent, so that if life happens to you, that person that you appointed has the legal authority to act on your behalf, so that your life will continue to run without the judge being the one appointing someone. First of all, to get to the court in Maryland, before a guardianship judge, it could take 3 months. Who has all that time to wait sometimes? Sometimes 1 week is like forever. Am I right? So why would you want to wait for 3 months? Because it was subjected to the court's timetable. And now when you get before the judge, there may be conflict. So for example, there is a mom. The mother, was very sick, and she was, very sick, and she needed help. She did not appoint anyone as an agent. She did not have any legal document called power of attorney in place. She did not have any legal document called healthcare directive in place. So unfortunately, she has a daughter. She has 2 daughters and 1 husband. Okay, so unfortunately, the husband is like a stepfather to the children. So when this time came, things were not going well. Probably there was mismanagement of fund by one of the children. So the dad was not happy about it, and things fell apart between the stepdad and the daughter, or one of the daughters, or maybe 2 of them. So at some point, the child was not allowed to see the mom, and she didn't know how our mom was doing. They had to go to court. The daughter went to court to be appointed as a mom's guardian. And then the father opposed, the stepdad opposed. and now there was conflicts between a stepdad and a daughter over the mother slash wife. Is that what that woman really wanted? No. But because she didn't have any plan in place, she didn't say who she wants to be a power of attorney or an agent, then there was a conflict between the husband and the child, all because of the mom. And these are loved ones. This happens a lot. So you want to have this legal document in place for you while you're alive, while you have sound mind. When you can choose someone you know, like, and trust that will act for you in the events that you cannot act for yourself.
Um, these are actually family members, and they left. Someone left money for the 6 kids, and the 6 kids do not is not satisfied how the will was set up, and now they're fighting to change it.
That's possible. That happens a lot. A lot. There was a will, am I right? And one of the children was, or all of them,
All of them are fighting.
all of them are fighting
That's a lot of
because
money too.
it's a lot of money. It happens. But the person did the right thing by having a plan in place, by having a will in place. Maybe there's a defect in the will. Do you understand? Because there are wills and they're the right way to get it done. Do you understand? So,
Is it a recourse?
what?
Is it a legal recourse against the will? It's not final. A will is not definite.
So, when you have a will in place, they're supposed to do what you wrote down. Your family or whoever you choose as your personal representative is supposed to follow your instruction. Do you understand? But there are times when people do wrong things. So, for example, let's say a trusted child was asked by the mom to, oh, mom says, oh, maybe I'm sickly or she's sickly and she's getting old. Hey, daughter X, can you make an arrangement? You know, I need a will. Take me to a lawyer or something like that, or just get me a will. Then the daughter was trying to be cheap and went online and drafted something by herself and drafted in such a way that she gave a lot of things to herself when she had siblings. Do you understand? At the end of the day, maybe the woman trusted the daughter, am I right? And she just signed. When she passes away, by the time the will comes out, and the other siblings think, no, our mom shouldn't have done this. Or maybe the mom said, I'm giving things to you children equally. Or maybe there's been a conversation that makes it suspicious that there's something wrong with this will. It will end up in litigation. Do you understand? So, but the intent, first of all, is when you put these things in place, these legal documents, you're giving clear directions that is supposed to be followed. But if you have a will, let me tell you, if you have a will in place, it's like you're suing yourself. Okay? A lot of people don't know about it. It's like you're filing a lawsuit against yourself with your own money for the benefit of creditors. Because a will, if you don't have any plan in place, your people, family will go to where? Probate court. And if you have a will, okay, that's where they'll have to go as well. Okay? But there are better ways of planning if you want to avoid going to the probate court. It's better to have a will than to have nothing at all. Do you understand? So, did I answer your question? Somehow? Okay. So, the state's plan for you is called probate after the person passes away. And when you get to the probate court, there are a whole lot of people that are waiting to get the piece of the pie. Okay? Attorneys are waiting because you did not plan. Am I right?
Sure.
Or maybe you did not plan right. Attorneys are good people actually because they help you solve problems. They help you solve a lot of problems, legal problems. And we help you save money too. Executors, the people that you choose as personal representative, their executors' fees by law up to 3%. If you have a home, you'll pay appraisal fees probably. So it's especially when you want to know the true value of your home. Okay? Then you pay the court's filing fees. Then you pay the bonds fee because the court will ask you, you need to get a bond. Then probably there are a lot of creditors like those who were sick before they pass away, the medical bills,
What is the bond?
um, like an insurance. So it's like an insurance called a bond. Okay. So it's like I'm saying, bail when you bail somebody out of prison. When people bail people out of prison, they'll tell you you need to put down a bond for the person. That means a guarantee in form of some money that this person will not run away. So for this purpose of estate planning, you'll have to put a guarantee down in form of some money that you won't misuse this person's assets or money. Okay? So bond fees are there, creditors are there that you may have to pay. Newspaper adverts are also there. That's the most hilarious thing for me because when someone passes away, this is what happened. You go to the court, they'll do something called newspaper publication. So they'll say, "Hey, Mr. X or Miss Y just passed away. If she owes you some money, show up and come and take your money before we share our assets out." So all those people are getting money before your beneficiaries do. Do you really want that?
Of course.
If you can avoid it, why not? Okay? So at the end of the day, it's just a slow drip of water that your beneficiaries will get if you don't have proper plans in place. But you can put your lives and you can put the law, I don't want to say put the law into your hand. You can control what happens to your assets, who you give what to by having proper plans in place, or even without having to go through the probate court. Okay? So we've spoken about probate. Probate court deals with when someone passes away, the department you go in court, okay, is probate court. In Maryland, it's called Register of Wills or the Offense Court, okay? But when you go through probate, these are some characteristics of what is experienced. First of all, probate is public. And what does that mean? If you have a will, they're going to put your will, it's a public record. So if I go to the probate court in Maryland, I can go to a section to view people's wills.
And do they itemize and tell anyone what's
You just type the person's name. Do you understand? It's public record. So do you really want, is that the best option for you that you'd want? Maybe not.
So what's the choice?
I'm going to get there in a minute. So, also, in Maryland, it could take 12 to 24 months for the estate to be administered before your beneficiaries can get what you really want them to have. Do you really want to stay that long, or do you really want your beneficiaries to stay so long because they have to go through the court process before getting what you want to give to them? Yes or no?
No.
No. And also the court of probate could be high, like the pipeline I just showed you earlier on. So there are numerous, there are a lot of ways. Once you have something to say, there are a lot of ways that we can better plan. Okay. So what I've said so far is this: if you have only a will in place, you're inviting your family to go through the court process, and it may not be the best option. Okay. It's a good way. It's good for the fact that you live in instructions. Okay. But it's not good because what's the letter after A is not only B. There are a lot of A, B, C, D, E, F, G before you get to Z. There are a lot of hoops you have to jump. Okay? So these are some of the things you go through when you have to do Maryland probate. So it's important for us to know that we need to keep our families out of court. Okay? As much as possible, you want to keep your families out of court and out of conflict. So, from what I've said so far, is that something that you'd like to do? If that resonates with you so far, please check the first box. I want to keep my family out of court and out of conflict, if possible. Please check the first box. I want to keep my family out of court. Something about probate. I said it's public. Am I right? Do we know those people? Aretha Franklin, the musician, Chadwick Boseman, the actor. Do we know them?
Somehow.
Somehow we've heard about them. They went through probate court, and this is someone's will. Jackie Kennedy's will. It was pulled from the probate record. So we can do better than this. And the sad thing is this: some of them know better. Am I right? But they didn't do the right things.
You're saying even though you have left a will, it still goes through the probate court.
Exactly.
Not
Exactly.
just went to probate if you didn't leave a will.
It still goes through the probate court. If you did leave a will, you have to end up in probate court because the judge have to be able to administer everything before your beneficiary gets title to your
So
assets.
it's either way, still probate.
So probate. But what we're going to say soon is there's a way to avoid probate court, okay? There are better options for you to avoid probate court, and we'll get to that soon. When you don't do proper planning, your beneficiaries will receive your assets outright and unprotected. How many of us have like 18 years old children? 21? Anyone in their 20s that are your children? Any 30s? 30s? Great. All right. So this may not apply to you directly, but kids don't get where you live for them until they become an adult. All right. And when they become an adult and turn 18, they are going to give them those assets directly. So they'll have like the representative or someone that will be keeping that money for them, until they become an adult. So let's say, for example, your total assets is 500,000, okay? Or let me say 250,000, to make it a little relative to everybody. When the child turns 18, let's say a parent passed away when the child was 15 or 12. They cannot have those monies. They cannot have those life insurance policies, okay? By the time they turn 18, then they'll give them the life insurance policy. But someone will be managing it for them. You know, they need to go to school, they need to pay for college, they need to do this and that. Before then, when they become 18, two things are likely to happen. Is it that the money is depleted because someone may be mismanaging it, like the life insurance example that we gave before, or if it's properly kept for them, they're going to get everything outrightly. So let's assume that they get this money outrightly and it's $250,000. Would you want to give $250,000 outrightly to an 18 years old child?
No.
No, I agree. Because what are they going to do with it? Spend it, and it's going to be gone in the twinkling of an eye. So, planning, part of planning, proper planning, is that you plan in such a way that the kids are not getting whatever you're giving to them when they just start to become adults. You can make plans to say, hey, this is when I want you to get this. For example, I give you 50,000 at 18 or at 21, whichever age you want, and probably another 100,000 at 25, and another 100 at 30, however you want. If you plan well, you can save those things, but you may not be able to see them in the will. It doesn't really give that opportunity. Okay? So someone, for example, I knew, his father passed away and gave him 150,000. He got the 150 at 18, then decided not to go to school. He got his college degree probably when he was 30 years old. Why? Because he had access to money. Why is he going to school? So, if this story resonates with you, if you want to ensure that your children's inheritance is not given to them at 18, please check that box. I need to make sure my kids don't inherit money at 18. Check the box. Or maybe it's your grandchildren that you're leaving some things for. Then you let them know. At least you have that knowledge. Or also, an important thing is that when you do proper planning, you can do a planning in such a way that the inheritance that you're giving to your children will be protected from lawsuits and creditors and spouses. Okay? People don't know. Okay? So they leave things to their children outrightly. So back to our example of a child getting $250,000. So the child got $250,000 at 18, got married at 19 or 20. Now it becomes, didn't know to keep the money separate. Am I right? Now it became a joint asset because she put the money, or he put the money in a joint account. Now it becomes a joint or a marital asset at some point. If unfortunately they get a divorce, now they'll be in court. Am I right? So is it going to be okay? So the father left 250 for the daughter. Okay, the daughter got married. Now the daughter got a divorce. The daughter put the money in the marital joint account with her husband. A divorce happened. Who owns the money? Both of them?
Depending on the state you live in.
Can you say that again?
Depending on the state you live in.
No.
No.
Both of them. So the judge is going to divide that money into 50-50 because she commingled the funds at some point. It wasn't properly protected. Did the father give the money to the son-in-law? Will the father really I've wanted that to happen so that the son-in-law got half of the money. No. But lack of proper planning makes that happen a lot. So when we're putting plans in place, we want to be thinking far and wide. Do you understand? It's not just about giving something to our children. We want to have an opportunity to make sure that the monies are protected from creditors, from lawsuits, and from
Can the
ex-spouses.
father instruct that money cannot commingle with the son-in-law?
Can the father instruct that the money? Yeah, but does it mean the daughter will listen to the instruction or know what to do? Yes, the father should. But a lot of times these children don't know that their parents are leaving inheritance for them. Am I right? So the daughter got the money because the father passed away when she was young. Would the father, that may not have even been a conversation, because the father was not expected to die young. Am I right? If the father was old, maybe he would have had a conversation with the children. But now there wasn't any conversation. It was a sudden passing away. And the child just became rich, you know, rich overnight. She doesn't even know anything about money, not financially mature. Not financially mature. And because she had life at a convenience, decided to either, spend the money anyhow. And because she doesn't know what to do, put it in a joint account because she loved the husband. But yes, if you plan well ahead, then you will plan in such a way that you'll keep the money in on a way that it won't even give an opportunity for the money to be commingled. Okay? And we can do that for adult children as well. For example, if you think our adult children are not financially responsible, or maybe we have special needs children and things like that, we need to make some extra layers of planning. So, I want you to look at the third box. I want to ensure that my children's inheritance is protected from lawsuits, creditors, future divorces, no matter how old they are. If that resonates with you, please check that box. If you really want to ensure that your children's inheritances are protected from lawsuits and creditors or future divorces, no matter how old they are, please check the box, that box. If you want to give it to them outrightly, that's fine, but it's not all that fine. It may not be all that fine. So, how well do you know your children and siblings?
Really.
How well do you know them? You see, when it comes to the matter of money, anything can happen. Okay, it's like when you pick playing Monopoly. You know that game called Monopoly? That you have to buy a home in Potomac and a home somewhere else, Piccadilly Street. Do you know what conflicts can happen when someone is playing Monopoly games? How much more when it's now real life money? Anything can happen. They can end up in the courthouse. Well, they can be nagging about each other. There could be an entitled child. There could be someone that says, we need to cut this house into two. It's our house. Or we need to cut it into six.
That's exactly what I was trying to say.
They may want to cut the house into six. Do you understand? Well, because there wasn't so much proper planning done. Do you understand? But we can avoid all that. You don't know what will happen when it comes to money. A good child can end up being, the problem child. And people say there's usually a black sheep in the family. And you don't know who the black sheep is going to be. Do you understand? there may be a problem child. So as much as possible, you want to have things in place, written down, and go beyond just a will. Do you understand? If if you want to avoid conflict, if you want to avoid court, then you want to look beyond just a will. And you could have a happy family if you have things in place and if you have reasonable beneficiaries. Children can be at risk even when there is a will, but I'm going to skip this because we all have adult children. Is that okay?
It's okay.
That's okay? All right. And that talks about guardianship. Basically, you need to name guardians for your young children. So if you have grandchildren, please tell your children that they need to name guardians for their children. Okay? So, do you have a healthcare directive that will work for you when you need it? How many of you know about healthcare directive or advanced directive or living will? How many of us have heard about living will? You've heard about it. How many of us have heard about advanced medical directive? Okay. So it works like a power of attorney. A power of attorney deals with finances and like everyday life. Okay? But the healthcare directive is focused on you making healthcare decisions for yourselves while you're alive. You have to be able to name or choose or nominate healthcare agent who will be able to make healthcare decisions for you in the event that you cannot make one by yourself. You find a lot of people in the hospital. The earlier example of getting bedridden, coma, accident, end time life issues. Am I right? If you don't make healthcare decisions for by yourself, choosing who you want, okay, then you're inviting conflict. Maybe many of us know the story a long time ago of Terry Scheibel.
Yeah.
Do you understand? This lady was sick, then she became a vegetable, brain dead. And when she became brain dead, she was in the hospital. She has parents. She still had parents, and she was married. And at some point, she was on life support. Okay, and at some point, the husband requested that she should be taken off life support. Then the parents objected to that, and you know, the husband is tired. The parents are like, we don't want our child to leave. Am I right? Who is the boss? Who has a better say? It should be the husband, maybe in your own opinion. Yeah, but it could have been the parents too. Do you understand? So, but anyway, because they were at loggerheads, the parents and the husband were at loggerheads, a decision couldn't be made about what should happen to Terry. They had to go to court. 10 years passing
In court.
in court. Hundreds of thousands of dollars. It's the issue, the matter went to the Supreme Court of Texas. The matter was brought before the then Judge Bush in Texas. The Governor Bush of Texas, then I think that was Judge. 10 years after, then the court ruled that she should be taken out of life support. That would have been avoided if she gave a simple legal document called Advanced Medical Directive or Healthcare Directive, saying, I want my parents to make healthcare decisions for me, or I want my husband to make healthcare decisions for me. Or say, well, A should make the healthcare decisions, and if it cannot, then the next person. You understand what I'm saying? So, we don't want to put that kind of sensitive decisions on other people because they're not mind readers. And if you have more than one child, or if you have a child and a brother and a sister, then there will be confusion because someone doesn't want the parent to go, and another was like, "Go, Diary, just go." Do you understand? Sometimes, even since someone on life support for long could be like terrifying. Do you understand? Because they could be suffering. It depends on their condition. So you want to make such a decision by yourself, and it's important that you have that in place. Like when you're going for an operation or surgery, some hospitals ask you for to sign documents. Am I right? Some people know of DNR.
So that's valid.
It's valid. But if you have these decisions made ahead of time, you're able to choose who you want. Do you understand? And not only who you want, how you want to be taken care of. How long will you stay on life? Do you want to stay on life support, or you don't even want life support at all? You're able to make those sensitive decisions so that there won't be conflict in your family, number one, and so that it won't have to end up before a judge who is going to choose who your healthcare agent will be. A lot of times when people don't make these decisions by themselves, the judge will be the one making the decision for them. Okay? So, back to the story of someone that ended up before the court. The stepfather and that story. So, at the end of the day, do you know who the judge chose? Neither of them. Neither. Well, because so let me review it. The judge chose the husband as the caretaker, a guardian over the person, but then chose a lawyer to be the guardian over the finances.
Sounds good.
It sounds better?
Yes.
Okay. So, is that what the mother really would have wanted? No. But do you know what happened years after? Anytime the lawyer will go to court, the lawyer will be charging hourly rates, hourly fees. And the lawyer had a say over a lot of things. The person that has the cash has the say. Am I right? So the money was depreciating because the lawyer was getting a lot of attorney's fees, among other things, and cutting the shots. So the money was going down, and the guardian over the person could not do so much. And the guardian was like, I want to go back to court. I want to go and complain about this lawyer, but the judge wasn't believing him. Do you understand? So at some point, there wasn't so much money for that woman to stay in a house. So the lawyer said, sell the house. We're going to put you in, a nursing home that is, we'll pay for it. And that was how that person's assets and money just dwindled and dwindled and dwindled because an attorney who didn't really have an interest at art was in charge of our finances, the guardian of our finances. So she didn't make good plans. Had she chosen who she wanted to be the guardian over our person and the guardian over our property and the guardian over our finances, am I right? Would it have been the stranger lawyer? No, because she wrote down what she wanted. The same thing with healthcare. You understand what I'm saying? So make all those decisions ahead of time so that a judge is not the one making them for you. And when you do, you're turning your wishes into directives. Okay? You have the choice, you're making the choice, you're turning your wishes into directives. So I'm going to go to the next question. If you think from all I've said, You need to have a power of attorney or a healthcare directive in place. Can you please check that box? If you need a power of attorney or a healthcare directive, please check the box. So now I'm going to the choice. I told you several times that we have better choices. Am I right?
Yes.
Yes. If you want to avoid probate court, okay, the foolproof way to avoid the court is to have a fully funded living trust that has disability provisions. So we call it revocable living trust for short. So it's not just lawyer, I need a trust. I need a living trust. And they send it to your email because you'll be confused about the content. Do you understand? It's not just even about signing the trust and thinking everything is in place. It's about what we say fully funded. Someone say fully funded. Fully funded.
What's the name?
I'll tell you in 1 minute. Please always say fully funded.
Fully funded.
Revocable living trust. Okay, so I'm going to break it down for us. Fully funded means you put your assets from your personal name into the name of the trust, like retitling. Okay? So for example, how many of us have homes in our names? Okay. So anything in your name only goes through the probate court. Okay, after you pass away. So if you have a house and it's in your sole name, it goes through the probate court. If you have a house and it's in a joint name, the house goes to the second person if one of you pass away first. But if two of you pass away about the same time, which is a probability, it doesn't happen often, then if two of you pass away about the same time, it goes to the court, probate court. Okay? To avoid the court process, instead of your home being in your name, you retitle it. You create a living trust and you retitle the name from your personal name to the name of your trust. Do we get it? The same thing with the other assets that we have, like your bank account. Okay? So you retitle your investments. Okay? Your bank account, you have to retitle it to. Sign the signature card. Change your bank account from your name to the name of your trust. Your deeds to your home. You'll sign a new deed, retitling your home to the name of your trust. And then you record it. Stocks, personal property should be assigned. And you change the designations on things like retirement accounts and life insurance. So, for example, how many of you have life insurance again? How many of you named beneficiaries in your life insurance? Yes. It's important you name the beneficiaries because those go to the beneficiaries you name. Okay? The same thing with your retirement account. Make sure you name beneficiaries. When you're doing this, you're funding the trust, okay? In such a way that nothing is literally left without a destination or a person that will have it. So if at the end of the day there's something in your name, let's say you have 3 houses and you retitled one and you did not retitle the other 2, the other 2 will take it to probate.
The two ones.
The what?
Just the two.
The 2 that you did not retitle. Do you understand? But if you have a trust in place, then make sure you fund. That's why we say fully funded. Okay? We look through all your assets and make sure everything is done properly, including your car.
Is it the same as revocable living will?
So it's not revocable living will. It's called revocable living trust.
Oh, okay, there's no such a thing.
There's no such a thing as revocable living will. But there's something called living will. Okay?
What's the
The
difference?
living will is under the healthcare directive that I spoke about, where you have to say whether you want to be buried or cremated, whether you want to be on life support or not. Those are living will. Okay? Is it clear now?
Yes.
Living will is under, it's part of healthcare directive. Revocable living trust is what keeps your assets out of probate court. So what we want to do is take our assets from our name and put them in the name of the trust. So we said with disability provisions, because when you have a trust, it's not only about after you're gone, it's also if you become incapacitated, there are provisions that will take care of them. You've named people that will be your successor trustees in that regard.
Okay. Question is, uh, regarding the trust, can two people put the individual asset into one trust?
So, for example, yes, there can be a joint trust, and that is popular with people that are married. So, if you're married, you can have one trust and you put your assets in there. Okay? So, the only way to keep your family out of court, either in the event of incapacity or death, is to have a fully funded living trust. This means that you've got your trust prepared, it's customized to you, it's drafted to keep your family to stay out of court in the event of incapacity or death. There are a lot of decisions that you can make in a trust. For example, when you want the inheritance to go to your children, at what age, at what stage? Do you want them to use the money for college, or you want them to use the money for their marriage, or just for everyday life? Or how much do they want to get per when? Let's say yearly or quarterly. There are a lot of decisions that you can make when it comes to having a trust in place. How do you avoid taxes? How do you avoid all those fees? If you don't go to probate court, will you have to pay all those fees?
No.
No. All right. And having a trust is private, it's not public. Okay? And it saves you cost at the end of the day. It saves your it's also preserves your family's asset, and you have a lot of control over what you even, what you're saying after you're gone. And you can keep your family's assets from creditors and lawsuits and a whole lot more.
Can you do that?
What?
Keep it away from creditors?
Mm-hmm. It's not like you will be irresponsible. Do you know if you have, let's say you have a loan on your house, the responsible thing is for you to pay your loan. Do you understand? So you won't come to a lawyer and say, "Lawyer, I have a loan. I don't want to pay the loan, a mortgage on my house." No, that's not right. But because your trust is not exposed in court, nobody sees what is there. Am I right?
Or I'm just looking for the difference between
Um,
will and
Okay, so when you say a fully funded trust,
Mhm.
explain that fully funded piece of it.
That's what I mean.
retire.
Retitling your assets from your name into the name of your trust. That's what it means to fund. So if you put all your assets there, that's full. But if you leave something out, it's not full. So you have to visit all those. Your house, your bank, your investment account, your personal property, your stocks, your life insurance, all you have to revisit everything you have. Do you understand? And there are ways that there are provisions under the law on how you can put all these things in a trust. and we guide you to get them done.
Okay, so you put everything in there, but I'm saying, okay, you say your house or your car, you still owe money on them.
Mhm.
Have to-
Okay. Yeah. So the deed title will change. Okay. But you're personally responsible to pay your loan. You'll just inform your lender, hey, I created a trust, and say, hey, send the trust document for record. But you signed the loan document, the deed of trust. Am I right? You're still responsible. While you're alive, okay, you're the grantor and you're the beneficiary.
But I'm saying, if you die before you pay off that loan,
Then your personal representative, aka successor trustee, will
create funds
administer
to pay.
and pay
They assume.
if that's it.
They assume.
And they can assume as well,
Okay.
but they administer your estate to make payments of whatever debt you have.
Can a mortgage company decline to let you put a property in a trust if there's a mortgage on it?
Yes.
Can a lender decline for you to put your house in a trust?
If there's a mortgage on it?
So let me tell you the truth. You put your house in a trust even before you tell your lender.
Huh?
You put your house in the trust even before you inform your lender.
Oh, it's not, they don't
That's
have
not
to approve.
illegal. No, they don't have to approve.
The reason why I asked is because of a situation where that happened. I don't know if the person told first, but the lender refused to let that house go in the trust.
No. The lender doesn't have authority.
Well,
Over
when
the
they refused,
trust.
I meant all of a sudden it's like they wanted full payment for it.
So
Instead of-
what the lender wants is their money.
Well, they wanted all of it.
No,
They wanted way
they
better.
want the house.
Hmm?
They wanted the house.
Yeah.
They
Say, for
want the
example,
money.
if you had $1,000 left on the house,
Mhm.
instead of waiting for you to make payments, they wanted $1,000 within a certain time. They like.
Okay, so maybe the person that would have happened if the person defaulted. And there were terms that says if you default, you pay in the whole.
It's not based on how it's written the mortgage.
It's whatever is in the mortgage, the deed of trust. There are a lot of terms in the deed of trust. So there's some terms in some deed of trust that says if you default, then we can get the full balance that is due from you.
Does
No, that's
any of
not
the
what I'm
language
saying.
there?
That's not
It
what
was
you're
not
saying.
default, it was
Depends
the
on
lender just didn't want the house to be part of a trust. So I guess in it said,
Mhm.
if that is done, then they want full payment. They didn't want to have to withdraw the partial payment.
I don't know. Then she should change lenders. There are a lot of options out there. So, but this is it. This is the practical thing. The practical thing is this: when you create a living trust, in our office, we're creating a deed alongside with it that will transfer your title from your name to the name of your trust. Then you go record the deed. The lender has the deed of trust. That's called mortgage. That 40-page document. That's the lender's document. It's different from the 2-page document called deed. The deed is like a 2-page document. The deed of trust is like a 40-page document. The 40-page document,
Which one goes to court?
the 2-page document. Okay? So once you retitle the deed from your name to the name of your trust, that's called funded.
Oh, that's what's fun.
Yeah. So once you change the name of your bank account from your personal name to the name of your trust, so let's say your name is Miss Smith, Jane Smith. Your bank account is in the name of Jim Smith. You go to the bank after you've created your trust to say, we're almost out of time, to say, I created a trust, I want to change my account to the name of the trust. They'll change it to Jane Smith Living Trust, for example. So that when you pass away, your things are not in your personal name anymore, they're in the name of your trust. We'll go into details like this when you schedule a family wealth planning session. You'll be clear Okay, if you're not clear now, there's so much opportunity ahead of you to be clear. So this is how you avoid probate court. All right, it deals with incapacity. It deals with after passing away, death, and it gives clear direction. And you have so much control to be able to save a lot in the form of estate taxes, to be able to save your money from going to children at 18, to be able, everything we've discussed earlier on. I want to finish through before we take questions because we have just about 12 minutes more. Is that okay? Thank you. So this is it. This is the deal. Okay. If someone says, hey, we can protect your assets from creditors, but you're not going to be the owner of your asset, you're not going to have access to it anymore, it's not going to belong to you, like it's your home, but you're not the, you don't have control. Will you really want that option?
No.
No, but we can provide, this option is revocable. That means you can make changes. That's the revocable part. You can change it. Leave in trust. It's yours while you're alive. Then when it's gone, it becomes like a will. People will do what you say. Okay? Please write down your question. So, in the last seminar, someone asked me, he said there are a lot of, you told us a lot of stories about how things did not work. Am I right? Tell us a story about what worked. Somebody that did something that worked well. So, this is a story of someone, and her name is called Jane for this purpose. Jane is a married woman. She has 2 children. She has home, bank accounts, and all that. She had about having her estate plan done. So rather than, because she has a home, she has all these estates, instead of just having a will, she decided to go through a lawyer to create a revocable living trust done for her. Unfortunately, she passed away. Revocable living trust, a will, a power of attorney, healthcare director, all the things, all the 9 years that we've spoken about today. When she passed away, it was easy for her children. Number one, she's named legal guardians for her children, so the children did not end up with strangers or not have to go through CPS. The people that she plans to take care of her children are the ones that were taking care of them. There was no conflict. Then, when it came to her asset did not go into her children's name directly because they were minor at the time she passed away. They were in the name of a trust. The assets were in a trust on the children. They didn't get it at 18. She said, give out to them at 22. So when the children became 22, the assets, out of the assets was distributed to them at 22. She also said, use some of these assets to take care of them, their health, their education. So they went to school without loans. She had a good trustee that she chose, and things were done without issues. Also, before she passed away, she needed someone to take care of her affairs. She's already named an agent in a power of attorney, so she didn't have to go through court. So, Jane did the right thing. Her children got the assets at 22, 25, and 30. There was no conflict. They had their school fees paid. There was no issue when it came to who will take care of her needs before she passed away. She didn't have to go through court for that. She didn't have to go through the probate court as well, or our trustee didn't have to go through the probate court as well after she passed away. And our children got a whole lot more faster within 3 months, not 24 months. Do you understand? And of course, our trust was private, it wasn't public, and things cost less in the terms that there weren't all this hurdle of everybody taking their share before things went to our family. So that may not be an interesting story, but it's not a life of drama. You know drama? Who wants drama in their family after they're gone? Do we? That's why it's called drama. But if you want to avoid drama, please plan. Okay? Please plan. Put an estate plan in place. And we can help you achieve this. We've spoken about this. There are a whole lot of things you can do with having a trust in place that having a will not allow. Okay? So, and it doesn't really cost much. I think someone asked the question about what's the difference between a will and a trust. So I'll get into that, then I'll get into this. A will is an instrument that allows for advanced planning, but when you have it, it's like government controlled. You are able to say who will do stuff for you after you are gone. You're able to do an administrator, give the name of an administrator called personal representative, and you're able to give gifts, to people. But it's simple a lot of times, and sometimes you're able to say this goes to this goes to that. But it's court controlled. Okay. A trust is a more sophisticated way of planning. It's private, it's not court controlled. And it gives you a lot of leverage to get things done beyond what a will cover. It covers for both incapacity while you're alive and after you are gone. And your things are still going to be yours. There's different types of trust. There's some trust that, some people want to keep things away from creditors, but at the end of the day, their assets are not theirs anymore. I don't know. Some people take that when they have a lot of things to cover away. But this is easy for a whole lot of people. It saves you time, it saves money, it saves your assets, it gives you a lot of control and leverage. It's better than having a will. It's a little sophisticated, a little more money upfront, but a whole lot of ways to save headache and to keep your family out of mess, to keep them out of courts, to keep them out of conflict. And it's very difficult for people to sue their siblings when you have a trust. It's very, very difficult. It's not as easy as the sue when it comes to a will. Alrighty. Oh, sorry, I missed something. So people ask, when do you need a trust or when do you need a will? See, some people go through DIYs. You know what DIY mean? Do it yourself. And they go online and they want to get things done. They get their families in troubles because they don't really know what they're doing. And another thing is that after those documents are drafted, it says, please give it to an attorney to review for you. So why go there? And if your life is not a boilerplate, is your life a boilerplate? So simple. You don't have children, you don't have money, you don't have clothes, you don't have a car, you don't have. If your life is a boilerplate, then you can go to Staples. Do you understand? Or you can go to Rocket Lawyer or LegalZoom. But a lot of people, their lives are not boilerplates. So you want to plan specific to you, specific to your family, specific to your assets. When you come before me, what I'll do for you may be different from what I'll do for her. Because your life may not be the same. You understand? So have a comprehensive estate planning done personal to you. So when do you need a trust or versus a will? If you have assets less than 50,000, maybe you can do a will. If you have assets over $50,000, it's better to have a trust. So if you have a home, most homes are over $50,000, you may want to look at a trust. Okay? And that's the second one, if you own a home or real estate. If you have minor children, you may want to look at a trust. If you have a blended family, you may want to look at having a trust. You know why? because the new wife may not give something. So a little story. We're almost out of time, but a little story is this: I give all I have to my wife. Then the person passed away. The wife remarries, and the wife made a new will. I give all I have to my new husband. The wife passed away. Then the new husband is there, but they had children from the first marriage. So what the new husband did, he made a new will. I give all I have to my children. So it is inherited the children of the wife. So don't have just a simple thing done and think it's all covered. Do things well. You may want to have a trust if you have a blended family. If you have problem children who don't know how to use money, you want to have that. If you have a business, you want to have a trust. So these are examples of situations. So when you come and say, "Oh, my life is just simple," it's just simple. I just want to give everything I have to my daughter. Simple. It may not be that simple. Okay. So 3 mistakes. Can you identify 3 mistakes people make from everything we discussed today? This is a question for you. Can you tell me 3 mistakes people make when it comes to estate planning? Don't do anything.
Not updating their plan.
Not updating their plans. Thank you. One more. Anyone more?
What was the first one?
Not doing anything. Not updating their plans. That's the second one. Anyone more? What did you learn?
Do a will instead of a trust.
Doing a will instead of a trust. Exactly. So those are some of the things. Those are some 3 mistakes. How can you avoid them? How can you avoid making those mistakes?
Fully funded it.
I'm sorry, I didn't hear you.
Fully funded.
Fully funded. Is that what you said? Have a fully funded living trust done instead of just a will. Thank you. So, can you tell me some of the takeaways from today's seminar?
Plan.
Plan. Thank you. Any other one?
Choices.
Yeah. Trust. Thank you. Any other one? What did you say, ma'am?
Choices.
You have choices. And it's better you choose so that a stranger judge or a stranger person will not be one making the choices for you. All right? Thank you. How do you get started? Sorry, we're out of time, but we're rounding up. How do we get started? We make it simple for you. Please schedule a family wealth planning session. It's a 2-hour session with me. We discuss personally about you, your family, your assets, how you can have a trust in place, and it doesn't cost. We're going to make it simple for you. Please, how do you get a family wealth planning session? First of all, thank you for coming in today. And because you came, we're going to give you a $750 gift certificate. Okay. A family wealth planning session is about $750 in value because it's a 2-hour meeting dedicated to you. If you're married, you come with your spouse. Okay. And how will you get a gift certificate today? I think this is $250, but we have 2 of it. Okay. How will you be able to get one? Please submit this. Submit your worksheet to Ms. Taya. When you submit your worksheet to Ms. Taya, she's going to give you the gift certificate. Then book a session today. Okay? Book a session today. When you book the session today, we have our dates available that you can choose from. It's first come, first serve. You book it with $20 to secure your appointment. Okay? When you come, please come. You will have, it's educative. It makes you to be financially organized. It gives you the opportunity to make empowered decisions. And you will know with certainty that your family will be guided throughout life and in the event of incapacity or death. we operate on flat fees. You will know everything about fees during the family well planning session. But when you come, we'll give you an intake. You let us know about yourself, your assets, and all that. Then we'll have a good session together. We'll make the best use of the session. But submit this, get this, and when you schedule, 1 minute, ma'am. When you schedule a family well planning session, we're gonna give you. I'm sorry, this is the 750 gift certificate. When you get this, and you pay $20, it gives you the 2-hour sessions free with us. All right, and it has a deadline on it too. When you schedule, you'll get the digital assets checklist, and you also get an additional $250 that you can use as a coupon credit towards any service you choose when you engage us. Okay? That's how simple we've made it to be. What's your question, ma'am?
How do I get a price for this service, the revocable living order? The price.
The price, you will know the price of that service in a family wealth planning session. So schedule a consultations, that's a consultation is called a family wealth. No. So that consultation is $750. We're giving it no. It's a 2-hour session. We'll get to know you, your family, your asset, what you need. You need a family wealth planning session. We'll be able to tell you what exactly you need. If you don't need one, I'm not going to give you.
Well, I looked into the living.
But when you get this, the session is literally free. Do you understand?
Which one is that? I'm confused.
We're giving you a gift certificate. We're giving you a coupon
Okay.
that when you present this, you don't have to pay for the session, or you're paying $20 for the session instead of $750. So it's going to be a free session. It's going to be a $20 session. Do you understand that?
You understand what you're saying?
Yeah.
When you book it today, you paid on $20.
All right.
We'll give you
need a
this.
certificate for $750, which you bring when you come to that 2-hour session. You give her that coupon. All it cost you was your $20, but she goes through with you. And then if you need her services, then you'll apply for the services, and you're gonna get another coupon for $250, which you can use for whatever services you need.
Quick question. I didn't have any questions. I just wanted to throw a question out there. The trust, it's recurring fees, or is it a one-time fee?
It's a one-time fee,
Okay.
a one-time flat fee.
Okay. The other thing I had was
Just
if you get a trust, and let's say you move your assets out of your name into this trust. If there's no trustees left on it, let's say your trustees and you are dead, who does it go to?
You have 2 kids.
So that's part of the planning. So when we're doing the planning, we're planning beyond you.
Okay.
We're planning beyond your children. We're planning like third to fourth level.
Okay, all right.
And a trust can be, in place for 99 years or as long as you want it to, as long as there are people that will be beneficiaries.
So you got fully funded trust, and let's say all your assets are in that and they're not in your name, you get a divorce, and your spouse isn't listed in it, they wouldn't have any access to that.
No.
That's all my question.
Okay.
Sorry, I'll let you finish.
So I think we'll wrap it up. So this is the advantage that you get with us. It's flat fee. You're planning ahead to avoid problems, and we're relationship based. Okay. It's not hourly fee. It's not a firefighting approach, and it's not transactional. Our firm is relationship based, so it's not about a case, it's about your life.
Okay, so let me ask this question. If most of, say, my assets are like my 401k, my IRAs, and my investments, which I have already specifically named
Beneficiary.
my beneficiaries, um,
They don't.
is this having a living trust is still advisable?
Maybe not.
I mean, I do have a house, that's not.
Yeah, maybe not. So I think she said, when you put something POD, thank you for bringing it up because that will answer your question as well. When you put an account and all those IRAs and life insurance, and you name a beneficiary, or on your bank account you say payable on death, and you have a beneficiary, it goes to those beneficiaries directly. So as part of, you may not need a trust. Maybe you're not married, you may not. If there are other things that we need to think about, like why you need a trust, you understand? Let's say you have a problem child, or you
Or have
think
my
this,
children.
then you may want to have a trust in place because it's like a double layer protection if you have a trust. But it's okay to name a POD. But if, for example, you name the POD and the person you named as a beneficiary passes away before you, then your assets will go through probate because there's no beneficiary.
Well, I mean, like, for instance, I'm just looking at say my 401k, it might give me to put primary beneficiaries and then you have a
Contingent
contingent.
beneficiary.
So if you have a
So
contingent.
it's fine. It's fine. You may not need a trust. All this, what you named, don't go into a trust.
Right.
But we review at all those things as part of your estates to make sure you properly named beneficiaries where you need to name them.
Okay.
Okay?
So having that session is
It's a review of all
review everything you have
everything
to
you have.
see whether or not have properly.
exactly. Exactly. So please, I think we've gone through this before. Please submit your green sheet, book a session. We have limited space before our next meeting in about 6 weeks. Let's get this done. Don't procrastinate anymore. And this is how you can reach us. If you need other things, the third section is how else can we serve you. So, for example, if you want to schedule a family or planning sessions, we also have e-newsletters. So if you want to be put in our e-newsletter, so you get weekly e-newsletter, check it. Also, we have this book, Reckoning Underwear. It's about legacy planning, estate planning book. It's lovely and it's interesting. We can send an e-copy to you. So check that box as well. And if you want to have a follow-up call, so let's say you're confused, or you still want to have a follow-up call with me, I'll offer a 15-minute call. Check that box, and someone will call you to schedule the 15-minute call. So I really appreciate you coming here today. Thank you. Sorry that we over time. And how did you like the session? Thank you. Please write it down. It's informative. Thank you so much for coming today. We appreciate you. We'll want to see you at the Family Wealth Planning session. All right. So at the Family Wealth Planning session. So go to the back of the room and schedule one.
So you say it has to be within the next 6 weeks?
Yeah, better still. Yeah.
But
So that you'll be able to make use of your coupon. This has to be done, within the next 6 weeks. Oh, we have a time within the next 4 weeks actually. Book a session before February 28th.
And
Okay,
the calling
and what time are you looking for? Is it?
Get it. Get that thing. Get the paper.
you're calling meetings and work session.
You can call into book this session too.
Thank you.
Thank you very much, everybody, for coming. We really appreciate it. God bless you. Have a good evening.
Can, you said that
Oh, let me stop this.
to get this service,
Mhm.
so it's only 15 minutes? Or I need to come to the